On July 14, 2022, Alex Murdaugh was arrested and indicted by a South Carolina grand jury on multiple counts, including 2 counts of murder and 2 counts of possession of a weapon during the commission of a violent crime. The indictment followed a multi-agency investigation into June 7, 2021, when Mr. Murdaugh allegedly shot and killed his wife, Maggie, and his youngest son, Paul. Prosecutors alleged the motive for the execution-style homicides was to distract from Mr. Murdaugh collapsing financial schemes. Earlier that same day, the CFO of his law firm had confronted him about missing fees, and prosecutors argued Mr. Murdaugh killed his family to generate sympathy and buy time to cover up his theft of millions of dollars. By eliminating his wife and 1 son, the path was cleared to gain full access, control, and liquidation rights over the family's massive multi-million-dollar estate assets. This financial motive was later highlighted by leaked recorded jailhouse phone calls between Mr. Murdaugh and his surviving son Buster, which exposed their private coordination regarding the family's remaining wealth and properties. The State Law Enforcement Division, known as SLED, initiated a criminal action against Mr. Murdaugh after a critical video extracted from Paul's cell phone revealed Alex's voice at the crime scene just minutes before the fatal shootings occurred, completely contradicting his initial alibi. The double murder case was heard in South Carolina's 14th Judicial Circuit Court before Judge Clifton Newman, roughly 2 years after the underlying homicides. During the trial proceedings, SLED Senior Special Agent Ryan Kelly was called to the stand. While the trial centered on the double homicide, Agent Kelly had actually been brought into the saga as the lead investigator for the separate September 2021 roadside shooting incident, where Mr. Murdaugh allegedly claimed he was randomly ambushed on a rural highway and shot. After prosecutor Creighton Waters finished his direct examination, defense attorney Richard Dick Harpootlian initiated his cross-examination.
So let's see if we can do this quickly. Is that okay with you? It is Friday. Monday's a holiday. So let's see if we can't get through this. You are is it senior special agent?
Yes, sir.
Okay. And you investigated, your charge was investigating the so-called roadside shooting, correct?
Correct.
And as part of that, after Alec was airlifted to Savannah Hospital, correct?
Yes.
Okay. And did you go see him there?
Yes.
And did you talk to the doctors about his condition?
We made contact with medical staff there. I don't know if I specifically spoke to a particular doctor, but we made contact with the medical staff that were providing treatment.
So, did the medical staff tell you he had a shallow sort of trough wound in the back of his head, apparently caused by a bullet? Did they tell you that?
They did not.
Did they tell you he had a fractured skull?
They did not.
Did you look at his? Have you subpoenaed his medical records?
We have, but
Okay.
at the time of my arrival, the tests were ongoing, and that those documents weren't readily available to me.
But you've looked at him since then.
Since then,
So you would agree with me he had a fractured skull, a wound, a trough wound in the back of his head.
I'd agree that's what the medical records state. These appear to be a portion of Mr. Murdaugh's medical records.
I understand it's a portion,
Yes, sir.
but it's the sort of the summarizing portion, is it not?
Yes, sir, it is.
Okay. I think you furnished these to us. Do you have any objection?
Objection, Rule 801.
Well, let me ask you this question. Maybe this will make it easy. Who subpoenaed and got these records? Did SLED?
Yes, at the time of the incident, they weren't discussing his medical condition with us. I mean, we were able to, due to HEPA, they weren't readily providing us access to his medical records or consultation with his doctors. We had a general understanding based on what Mr. Murdaugh told us or told deputies on the side of the road, and based what he stated on 911 that he had been shot in the head. So when we arrived and we saw a subsequent injury.
Just let me cut to the chase here. Did you all subpoena the medical records?
Yes, we did.
Are these a portion of the medical records, the business records that you received from the hospital in Savannah, the Memorial Health?
Yes, sir.
Okay. Does that resolve that issue? Business records?
With redactions, no objection.
Admitted without objection.
Yes, sir.
Okay. Now, I could have you read that. Do you understand what it means?
I have a general, like I said, I'm not a doctor. I'm a SLED agent, so I have a general understanding of the terms on the page.
Does it indicate he had a furrow wound in his head?
I'm not trying to play coy. It just says, I mean, I could read it. If it says,
Okay, let me publish part to you and see what you think. Left posterior parietal subdural hematoma with adjacent blood products. What do you think that means? What's a subdural hematoma?
Obviously, it's a bleeding on the subdural part of his head, so it's
So it would be a brain bleed.
Absolutely, yes.
Okay. It says linear left posterior parietal bone fracture. That would be a fractured skull.
Yes.
Okay. Scalp laceration overlying the left parietal bone. That would be that furrow I'm talking about, right?
If that's what you infer to, I'm not a doctor. I mean, a furrow is, you know,
It's a
I can only
laceration.
testify what it states on the
Okay.
page.
And attending radiologist reviewed all the images and agrees with the interpretation. So a radiologist looked and saw a brain bleed, saw a subdural hematoma, saw a fractured skull, and made findings consistent with a bullet wound to the head. Did they not?
The medical professionals reviewed his charts and his tests. They came to that opinion. We refer to them as it relates to their findings.
I'm sorry, refer to them what?
We refer to them as it relates to their findings. If that's what they
Okay.
determined happened,
Okay.
we refer to them.
So he had real injuries.
There was a laceration on the back of his head that was consistent with a gunshot wound.
Fractured skull, subdural, brain bleed, right?
If that's what the records say, then yes.
During the cross-examination of Agent Kelly, a timeline was established regarding how law enforcement uncovered the nature of Mr. Murdaugh's injuries following the roadside shooting. Under the Health Insurance Portability and Accountability Act, medical professionals are legally barred from freely releasing a patient's private medical details or diagnostic results to law enforcement without proper authorization. Because Mr. Murdaugh's diagnostic tests were still actively ongoing at the time, the medical staff could not legally answer the agent's specific questions regarding the severity of the trauma. Because of this statutory privacy barrier, law enforcement had to rely entirely on what Mr. Murdaugh himself reported. Agent Kelly acknowledged that Mr. Murdaugh sustained a real, substantial wound to his head, a fact that initially corroborated Murdaugh's account and made his claim of being shot appear reliable. Under the statutory mandate of South Carolina Code of Laws Annotated 23-3-15, SLED possesses exclusive statewide jurisdiction over complex general criminal investigations. When an individual claims a gunman is at large, law enforcement is duty-bound under state police powers to exhaustively verify the facts, track ballistics, and scan the area for a threat. Stopping an investigation because a victim has an injury would be a failure of public duty. SLED was constitutionally and professionally obligated to execute its investigative protocol to uncover who actually pulled the trigger and ensure the community was safe, which ultimately exposed that the story was a fraud. Here, Agent Kelly had the duty to question Mr. Murdaugh about the event.
Now, as I understand it, after he was released from the hospital, he went to detox in Atlanta.
That's what y'all told us, yes.
I'm sorry?
That's what you told me.
Okay. And we called you from a facility in Atlanta to give the statement we saw earlier, correct?
You called me from a telephone. I don't know exactly what your location. I wasn't there with you, so I don't know where you called me from.
You're telling me SLED can't tell where a phone is?
Mr. Harpootlian.
I mean, if you're going to tell me that SLED can't tell us where a phone is,
Pose the question, you must give him an opportunity to answer.
I apologize.
Mr. Harpootlian, you called me. I don't know what number you called me from.
My cell phone.
Okay, so you called me from your cell phone. I have that number, so it identified as yours.
Right.
But I don't know where you were at. You told me that you were calling from Atlanta. I took you at your word, but I can't testify to where you were calling me from because I don't know.
Did you ever subpoena his detox records?
We made an attempt, but we had issues with them honoring an out-of-state subpoena.
Well, I mean, you can go to a court in Georgia and make them honor it, or we could have given you consent. Did you ask us for consent?
No consent was given.
No consent was asked for.
No
Right.
consent was asked. No consent was given. So
Okay. But we represented on that call that he was in a detox facility before, when we called you to set up the call in Atlanta, and he was now, and I think we've said on the recording, that the doctors indicate he's coherent, he's been through the detox, which is a pretty tough process, and he was willing to talk to you once he was competent to do so. Isn't that correct?
that's the information you relayed to me, yes.
Okay. Do you have any reason to doubt that?
No, sir.
Okay. And so as soon as he came out of the initial stages of detox, you don't know this, but we went down, we called you.
Mr. Harpootlian, you can't testify.
Who called who initially to set that call up?
I called you on the day of September 7th to reach out to let you know that we had some developments in the case and I told you that we wanted to speak to Alex.
Okay.
You told us that he was in rehab or was en route to rehab, and we would try to make some arrangements. We had initially discussed agents traveling to whatever facility Mr. Murdaugh was in to meet with him in an attempt to get a statement. That meeting did not materialize. On the afternoon of the 13th, you called me from your cell phone to set up a telephone interview. Given the complexity of the case and the fluid movements of the investigation, we wanted to, agree to that so we could get some type of. At that point, Mr. Murdaugh had obviously the story that he told us was not true, and we wanted to take that as an opportunity to try to make some sense out of the investigation, given that you and Mr. Griffith were there saying he was ready to tell us really what happened.
So he, through his attorneys, reached out to you to give this recorded statement we saw.
On the 13th, you called me, yes.
Right. And secondly, he admitted that he had stolen money, right?
Yes.
He admitted drug use,
Yes.
and he admitted that he'd lied, correct?
Yes.
Okay. And as a result of that statement, he was charged with insurance fraud, conspiracy to commit insurance fraud, and filing a false police report. Is that correct?
Yes, he was.
And by that time, he had moved from the detox facility in Atlanta to a rehab facility in Orlando, correct?
Correct.
And you asked that he surrender himself, and he did that, did he not?
Yes, he did.
He had his son Buster drive him from Orlando to Hampton County, and I believe you all met him and, by prearrangement, him and Buster at his mother's house.
The agreement was for us to meet you and Mr. Griffith with Mr. Murdaugh, that no stops be taken from Orlando to Hampton. We encountered Mr. Murdaugh and Buster pulling into the driveway of the Almeda property. So outside of our agreement, so Mr. Murdaugh was taken into custody as soon as he arrived at Almeda.
Well, so perhaps if we weren't going to Orlando, stopping to get his lawyers before he surrendered himself would have been a violation of our agreement?
No, our agreement was that Mr. Murdaugh was to go from Orlando directly to your custody. Buster, I don't fault Buster. I don't think that he was doing anything that he thought was wrong. He was just listening to instructions. But we were supposed to meet him with you, and he showed up at his mom's house. So he was placed under arrest at his mom's house.
Well, we showed up at Mom's house as y'all were taking him away, right?
After he was arrested, yes.
Right, but I mean, we were there minutes after you arrested him, right?
Well, yes, because they called you. So, and I think I might have called you to tell you that we were arresting him as well.
Right. He went to a bond hearing,
Yes, he did.
and he was granted bond,
Yes.
and one of the conditions of the bond allowed him to go back to Orlando to rehab, right?
Yes.
And he went back to Orlando to rehab
Yes.
until he was indicted on the financial fraud charges.
Yes.
Mr. Harpootlian questioned Agent Kelly to emphasize that Mr. Murdaugh became cooperative once he began his recovery. Agent Kelly confirmed that during their recorded phone call on September 13th, Mr. Murdaugh voluntarily came forward and admitted to 3 major wrongdoings: stealing money from his law firm and clients, struggling with a severe drug addiction, and lying to law enforcement regarding the staged roadside shooting. Under the South Carolina Code of Laws, fabricating a shooting incident and misdirecting law enforcement constitutes a direct statutory violation under South Carolina Code of Laws, Section 16-17-725. As a result of his statements on that call, Mr. Murdaugh was formally charged with insurance fraud, conspiracy to commit insurance fraud under South Carolina Code of Laws, Section 38-55-540, and filing a false police report. Additionally, misappropriating funds from clients and a law firm is a severe felony codified in South Carolina as breach of trust with fraudulent intent under South Carolina Code of Laws, Section 16-13-230, as well as grand larceny under South Carolina Code of Laws, 16-13-30. Here, Mr. Harpootlian's strategy seems to rely on establishing that Mr. Murdaugh was fully cooperative during his questions. However, this cooperation did not shield him from further prosecution. While Mr. Murdaugh was initially granted bond for the roadside shooting charges, the financial investigation quickly escalated. And because of these subsequent indictments, Mr. Murdaugh's initial bond was overridden, and he was taken back into custody and arrested to be jailed.
And his cooperation, when I say cooperation, the statements he made I understand you were only investigating the roadside shooting. right?
Correct.
So you weren't investigating the murder, you weren't investigating, I mean, I'm talking about Maggie and Paul's murders, you weren't investigating the financial crimes, only the roadside shooting, correct?
Are you referring during my interviews with the 3 interviews with Mr. Murdoch?
I'm sorry?
Are you referring to, in the 3 interviews with Mr. Murdoch, the first 2 interviews were conducted with him being considered the victim of a violent crime.
Right,
And
and then-
in the 3rd interview, you set parameters as his attorney, as to what information we would discuss
No,
on the call.
I'm
So,
not, but he did, when you asked questions about his bank accounts, he cooperated fully with you, right?
after some give and take, I think between you and I, he disclosed information, yes.
Right. And he admitted to you he'd stolen money.
Yeah, he confirmed that he had stolen money, because at that point, we had been told by other parties he had stolen money, and on the 7th, we recovered enterprise banking slips. So we knew we had documentation he had stolen money. He just confirmed it with his.
Did you know whether he knew he was just coming out of detox? I mean, certainly, many defendants would have never talked to you, correct?
Objection is sustained.
Did he have to talk to you?
Some of the best confessions I've ever got were from a defense attorney. So he spoke to me.
Not this defense attorney, okay?
Well, he still confessed on the call. So
I mean, there are defense attorneys and defense attorneys, right? Okay. So let me say this: as a result of some of the information you got, did you give that statement that he gave you? Did you give that to who was investigating the financial crimes?
That was a joint operation out of our office. There were several agents that were involved.
But
in
no agent in charge like Mr. Owens?
There was an agent, David Williams, Special Agent David Williams, myself, Special Agent Matt Wright. We've all had part in the financial investigations.
Okay, and as a result of his cooperation, partially, and what you already knew, you're aware that he was indicted on 90 indictments of financial fraud, which could result in life without parole for him. Do you not?
He was found.
If you'd answer yes or no and then explain your answer. Was he indicted on 90 charges of financial fraud and for which he faces life without parole? Is that correct? Just yes or no?
Objection is sustained.
I'm sorry, what was the objection?
There's an objection, and I sustained the objection.
I'm sorry, Your Honor, I don't understand the grounds for the objection.
401, Your Honor.
I'm sorry, I understand what 401 is. I don't know why it would apply to this.
Objection is sustained.
The information you got was voluntary about the financial piece of this was voluntary by him? No one threatened him? No one coerced him? He has 2 lawyers sitting there, right?
To the best of my knowledge, no one threatened him. I was not present with Mr. Murdoch at the time of giving his statement. I wasn't. It was over the telephone. Based on what you've told us, no one threatened him. Y'all
Nobody
were
had
there
a gun to his
representing.
head.
I wasn't in the room. If you did, I can't speak to it.
Mr. Harpootlian questioned Agent Kelly regarding whether Mr. Murdaugh was threatened, coerced, or subjected to duress by law enforcement before making his statements. Agent Kelly denied any law enforcement coercion, stating that the interview was entirely voluntary. Under the 5th and 14th Amendments, a confession must be entirely voluntary to be admissible. Any law enforcement officer who coerces a confession through threats, violence, or psychological manipulation violates the defendant's constitutional rights, rendering the statement legally inadmissible under the exclusionary rule. Here, Agent Kelly reinforced that no force or coercion was made during Mr. Murdaugh's free confession. Under Rule 401 of the Rules of Evidence, evidence is only admissible if it is deemed legally relevant to the specific case at hand. In this matter, when Mr. Harpootlian asked for a confirmation of Murdaugh's 90 financial fraud indictments and his potential penalty of life without parole failed to meet this threshold. Because Murdaugh was on trial strictly for the double murder of his wife and son, the severe statutory penalties of his separate, unadjudicated financial crimes held no probative value regarding his guilt or innocence of the homicides. Therefore, Judge Newman barred this line of questioning to prevent distracting the jury with legally irrelevant details.
Questions. That second time you took him into custody, do you know when that was?
I don't have the exact date in front of me. I apologize.
If I told you October 16th of 2021, would that seem appropriate?
I believe it was in the month of October 2021.
Okay. And tell this jury, how long has he been out of jail since October 16th of 2021? I mean, did he make bond?
I don't believe so, no. He
Okay,
had-
so
yeah.
he's been in jail since October 16th.
Objection 401, Your Honor.
Objection sustained.
What opportunity has he had since October 16th of 2021 to manipulate witnesses, to manipulate evidence, to manipulate anything in this case? What opportunity? Go ahead.
There's an objection.
I'm sorry,
Basis
what's
for the-
this objection?
Objection 401, Your Honor.
And response.
Well, Your Honor, no question, he's been in jail since October 6th.
Your legal response to the objection.
I don't
The
understand.
401 is the objection, relevance, and your response.
My response is that they have him, they're trying to portray him as this manipulative
Your Honor.
person, and he's not got the ability to manipulate anything after October 16th.
Objection is sustained.
That's not relevant.
Inappropriate argument to the jury.
I'm sorry, Your Honor.
Yes.
Now, did you tell anyone in his family the reason you wanted to see him while he was in rehab was to show him a picture of a truck?
The conversations about the picture of the truck, we obtained the picture of the truck on and around.
Excuse me, if you would just answer yes or no, and then you can explain your answer. We're going to go down this trail, and if you say no, then I'm done. If you say yes, then I'm going to ask you when you did it, and we don't have to go through this back and forth for the next 10 minutes. Did you tell anybody in his family you wanted to see him in rehab just to show him a picture, among other things, just to show him a picture of a truck?
I believe that was one of the items we wanted to discuss with Mr. Murdoch.
Okay. And so you were giving the impression that at that point you still believed him, and you just wanted to show him a picture of a truck.
401, Your Honor.
Relevance? Really?
Let me hear that question again.
You indicated to a member of his family you knew was communicating with him that all you wanted to do was show him a picture of a truck.
Object to the form, Your Honor.
It's cross-examination.
Thank you. Did you communicate?
What's the response?
I asked the question.
Could you repeat the question, please? I'm sorry,
Are you a senior special agent?
yes, sir, I am.
Senior Special Agent Kelly, did you communicate to a member of Mr. Murdaugh's family, Randy Murdaugh, that all you wanted to do was show him a picture of a truck? That was paramount to you, and that's what you communicated to Mr. Murdaugh.
Objection 401, Your Honor.
Objection is overruled.
The question you just asked me is that, and I responded to, that was one of the things. That was not the only thing. You know, we knew the identity of Curtis Smith. We knew the truck that Mr. Smith.
I didn't ask you what else you knew. I asked you,
Ask the witness to be allowed to complete his answer, Your Honor.
Okay. You may continue your response.
We wanted to meet with Mr. Murdoch to show him images of the truck. We wanted to show him to see. At this point, we suspected he was not telling the truth, and we wanted to see if he would continue to not tell it, to continue to lie to us about not knowing the existence of Curtis or the truck, or if he would, show some type of clarity. And
so, and this goes to sort of the same issue. When you wanted to see him, with the exhibits I just introduced. Okay. When you wanted to see him and you contacted me, I indicated he was in detox, right?
Objection to counsel statement.
Objection is sustained.
Were you aware that he was in detox in Atlanta?
I was aware that he was out of state, and based on the information you told me, and I took you at your word, that he was seeking treatment in an out-of-state facility.
Okay. And did I indicate to you, or did anybody indicate to you, in detox, you need an uninterrupted period to get off the drugs?
I believe that is what you explained to me.
Okay. And that he wouldn't be competent to communicate until he'd been, there was some hospital records, maybe I walked away. He would not be competent to speak with you until the doctor said he was competent, right?
On the morning of, on the September 4th incident, he consumed opioids that morning. He was not detoxing or coming off those drugs. He did not appear to be under the influence of any narcotics when we met with him in the hospital. He was on his cell phone, he was walking, he was talking, he was coherent. He was the victim of a crime, the only witness that we were aware of for that crime, so we obtained a statement from him so he could tell us what happened.
You would concede he'd been shot in the head on no one plowable ground, but he had a head wound, fractured skull.
Asked and answered. Beyond.
Objection sustained.
Okay. Did you ask a doctor if he was competent to speak with you?
Again, those medical records, the doctors
No,
would
that's
not.
not what I'm asking you. I'm asking you if you talked to a doctor and said, is he competent to talk to us? Did you do that?
Mr. Harpootlian,
Would you just say yes or no, and we can move
I'd
on?
like to ask the witness allowed to answer the question and object to the form.
Let me answer the question, yes or no.
could you repeat the question?
Did you speak to one of his physicians or any medical personnel and ask them if he was competent to speak with you in the hospital?
I did not.
Okay. Now let's look at part of the records that are in evidence. And there was drug testing done on this day, correct?
Again, they did not discuss with me his medical records. Mr. Harpootlian, they didn't talk to me about his medical records.
And you didn't ask them, did you? Did you ask them?
The testing that was
Did
being
you
conducted-
ask them?
We did not ask to discuss
Okay.
specific aspects of Mr. Murdoch's medical condition. We had to subpoena the records with a court order to have access to them. They will
So,
not discuss openly his medical records with us.
did you ask a doctor, I'm just repetitive, but if you had asked a doctor, they would have told you, according to these records, that he was positive for barbiturates and positive for opioids, would they not?
They would have told us they,
Objection sustained.
Were you, according to the records that are in evidence, were you aware that he was on opioids and he had a positive test for opioids and benzos?
once we have subpoenaed,
Would you please answer the yes or no?
once we got the records,
Would
we
you
learned
answer
that
yes or no?
Your Honor, I would object to him badgering the witness. The witness is entitled to answer the question.
You may respond as you see fit. Go ahead.
at the time of September 4th, we did not ask the medical doctors or the medical professionals any information about his condition because they would not discuss it with us. So if I had asked, they would not have discussed it. So we did not ask. When we obtained the medical records through court order, we were able to review them and learn after the fact the diagnosis.
Would you still have, if you'd had the medical records, would you have still gone forward with questioning, knowing he had opioids and benzodiazepines in his blood system?
At that point, he was a victim of a crime. He was the only witness to a shooting that we were currently investigating. I would have asked those questions, and when I found that they were consistent with the two other statements he had already given, it would have allowed us to move forward with the investigation.
Beg the court's indulgence.
As said before in the testimony, Agent Kelly could not freely access Mr. Murdaugh's medical records due to medical privacy regulations, forcing law enforcement to secure a subpoena and a court order to gain access. Under constitutional standards of due process, a poor law enforcement investigation could result in critical oversight and investigative blind spots, ultimately undermining the prosecution's burden of proof by introducing reasonable doubt. Mr. Harpootlian's line of questioning seems like an effort to prove the SLED agents were unreliable, aiming to expose a lack of due diligence in their investigation. Specifically, their failure to consult medical professionals regarding Murdaugh's cognitive competence before interviewing him in the hospital. Also, Agent Kelly resisted answering a direct question, relying on only one subject related to the truck photograph, attempting to bypass a strict yes or no answer to avoid admitting that the photo was used as a deceptive pretext to manipulate the Murdaugh family into a second interview. Furthermore, Mr. Harpootlian attempted to ask what opportunity Mr. Murdaugh had to tamper with the case, influence witnesses, or commit evidentiary spoliation while held in continuous pretrial detention under South Carolina Annotated Code, Section 171510, after October 16, 2021. By emphasizing his incarceration, the defense aimed to prove that because the defendant was already locked up, it was physically impossible for him to interfere with the case. But the argument was not admissible. On March 2, 2023, Alex Murdaugh was found guilty on multiple felony counts, including 2 counts of murder and 2 counts of possession of a weapon during the commission of a violent crime. On March 3, 2023, a judge sentenced Alex Murdaugh, who received 2 consecutive life sentences without the possibility of parole, parole. On May 13, 2026, the South Carolina Supreme Court unanimously voted 5-0 to overturn Murdaugh's murder convictions and ordered a new trial due to a major legal violation. The High Court ruled that Colleton County Clerk of Court Rebecca Hill compromised the trial's integrity. Motivated by a desire to boost sales for a true crime book she was writing about the case, Ms. Hill used her official supervisory position to improperly influence the panel. According to High Court, Ms. Hill targeted Murdaugh's credibility and defense by instructing jurors to watch Murdaugh's body language closely while he testified, warning them not to be distracted or misled by the defense's arguments, telling the panel at the start of deliberations that a decision shouldn't take long. The justices concluded that Ms. Hill had improperly interfered with the justice process, violating Mr. Murdaugh's constitutional right to an impartial jury untainted by external forces. While a new murder trial is being organized, Mr. Murdaugh remains incarcerated. This case illustrates the critical importance of investigative protocols in law enforcement interviews and the compounding impact an auxiliary hoax can cause in high-profile criminal trials. When a state law enforcement agent is tasked with investigating a violent crime where the primary suspect initially poses as a victim, the caution and the strategic awareness of the investigation must be reinforced. By highlighting his methodology and explaining to the jury his process of interrogation, Agent Kelly ensured that he followed the proper constitutional and administrative procedures during the investigation. Even though he confirmed he did not initially consult with physicians regarding the suspect's immediate medical competency or narcotic impairment due to strict HIPAA regulations, he corrected the gap in active documentation by subsequently securing a judge-signed subpoena to guarantee the hospital business records were properly authenticated, keeping the ultimate integrity of the criminal justice system intact. Comment below if there is a case that you would like us to cover. Thank you for watching, and don't forget to subscribe to more videos.